Okay, we're going to pick up the First Amendment here on slide 9. According to Blackstone's commentaries on the laws of England, and we're going way back to 1769, before we were a country, freedom of the press was interpreted as freedom from prior restraint. We've spoken a little bit about prior restraint, that this is the dirtiest term to any journalist. Nobody wants to be prevented from writing something before they write something. And so the laws of England believed that freedom of the press meant that we cannot prevent you, we cannot serve you with an injunction saying that you can't write that before you write it. Of course, this did not protect a person from punishment after the fact. So you can publish what you wish to publish and what your editor or publisher allows you to publish. However, you must be cognizant of the fact that you may end up breaking a law by doing that. Maybe your publisher is not as aware of First Amendment law as others, but you need to make sure, if you have any questions about whether what you're about to print is legal or not, you need to get most presses, most papers, most journalistic channels have attorneys on staff. So you go to the attorney and you get an opinion. Which law have we come across that allows for prior restraint? There was one law, not common law, that I told you about that deals just with prior restraint. I may ask you that in a discussion question. On to 10. Our founding fathers similarly thought of freedom of the press as a limit on prior restraint. So put that in your pipe and smoke it. That is exactly the definition of freedom of the press, is a limit on prior restraint. You can write that down. Now, ironically, just 7 years after the First Amendment was ratified in 1791, many of those who voted for it also voted for the Sedition Act of 1798, which is just the opposite of the First Amendment. The Sedition Act, I think I have it on this next slide. Yeah, here we go. This law made it a crime to, quote, write, print, utter, or publish any false, scandalous, and malicious writing or writings against the government of the United States, or either House of the Congress of the United States, or the President of the United States. Now, the First Amendment said that you could write about these things. Now, 3 years later, we have the Sedition Act that says, no, you can't. And then 3 years later, we go back again. As philosophies and attitudes changed, the act was allowed to expire in 1801. But it's important for you to note that our government can change things. These are not carved in stone. Laws can be changed. And to come out and say, you can say just about anything, and of course, the great thing about the United States is that we can criticize the government. There are countries where you are put in prison if you criticize the government, or you are killed if you criticize a particular leader. That will never happen here in the United States. If it has, I would like somebody to tell me about it. But that is not supposed to happen here in the United States. Now, another look at criticism of the government. As we have seen in recent years, especially since 9/11 and the ensuing Patriot Act, in times of national danger or national peril, restrictions on our freedoms become the natural state of things. you have to understand that sometimes we have to lose some of our civil rights in order for everyone to be safe. When you can't fly on an airplane with just anything in your pocket. You can't fly with a fluid cigarette lighter. Lots of things you can't have. You can't even have anything over 3 ounces that's a fluid. Like I had a 3-ounce bottle of expensive cologne taken from me at the airport. I cried. I didn't like it, but I understood what was going on. In times of national danger, restrictions on our freedoms become the natural state of things. Limitations on what we can carry onto a plane, having to go through body scanners, and being subjected to other security measures on our protections against search and seizure, etc. During World War II, Japanese Americans were put into internment camps. If you didn't get that far in history class in high school, I want you to understand that is one of the most egregious acts we ever took during a time of war in the United States. The first egregious act was stealing the United States from Native Americans. That was horrible. Then slavery. Then I'm not gonna put them in order. I'm trying to tell you what they are in chronological order, not in order of badness, I guess is the word. And then during World War II, if you had a Japanese-sounding name, if you, quote, according to some people, looked Japanese or Asian of any kind, you were put into basically a concentration camp right here in the United States. It's horrible to think that an American who happens to have a Japanese or Asian-sounding name can be thrown into a concentration camp just because of that. We've done similar things to Latinos, Hispanic people in this country, forcing them to show papers proving that they're American just because their skin is browner or their name is different. We can't allow that to happen in this country. So now we're on slide 13. And this is the second law I'm going to tell you about. We went through fair use, and now this is our first Supreme Court case from 1931. I do want to tell you that until we had the incorporation doctrine, you don't see many First Amendment cases at all. I think it was 1919 or 1920 before we started seeing First Amendment cases. And here, we're in 1931. Here's a story of Neer v. Minnesota, one of the most important cases you're going to hear about this semester. Jane Neer, who was the editor of a paper, today we would call it something like a rag, called the Saturday Press, which was full of writing against Jews and Catholics, was the plaintiff in this landmark case. Following the publication of the first issue, Neer's co-editor was shot. Believing that the police were not trying to find the shooter, Neer published his harsh criticism of the public employees, including the local prosecutor. Now, what did we just hear about that said we had the right to publish criticism of government officials? We were just talking about the, oh, here we go. We're running again. Think about that a second. The state had an abatement statute against malicious, scandalous, or defamatory newspapers, magazines, or periodicals, which gave state authorities the power to shut down Neer's publication, and they did so. But remember, we have the right After we let the Sedition Act expire, we had the right to criticize the government. So here we come. Let's see, that was 6 years later. That was in 1925 with the incorporation doctrine. Yeah, sorry. Lots of things to remember. Now here we are 6 years later with Neer v. Minnesota. So the state had not changed its laws, its statutes. It said you couldn't say anything bad about the government. This case went to the Supreme Court, which struck down the Minnesota statute, stating that it was too serious to censor charges of malfeasance of public officials. They determined that exceptions to prior restraint would be allowed for only 4 situations. Remember how terrible prior restraint is. Now we have 4 exceptions where we are going to allow it. And those are on slide 15. The courts have interpreted Neer to mean that few instances other than national security can justify prior restraint. The burden to be met is that the speech must clearly result in direct, immediate, and irreparable damage to our nation or its people. This was written by Justice Stewart in this decision later in 1971. That's 40 years after Neer v. Minnesota. Okay, I'm going to